Hello, good evening and welcome to another episode of Law and Order on another Friday evening. The program that features a specialized area of law with a specialist in order to bring you knowledge and awareness of it. Now, we all heard the term fundamental rights or human rights. We tend to usually confuse these two. But today, in order to find out what is the fundamental rights situation in Sri Lanka and what rights you have on fundamental rights, and to little bit go beyond that and see how it is working here, we have a special guest on that. And my guest today is Dr. Dinesha Samaratna, Senior Lecturer of the University of Colombo, a specialist in fundamental rights among her other areas. Dr. Dinesha, thank you very much for joining us again.
Thank you for having me.
And let's straight away start on with the question. Like I said before I go to the questions, people tend to confuse fundamental rights and human rights as well. So what is the fundamental rights and how are they protected in the constitution in Sri Lanka?
Okay. These are two different terms.
Right.
Human rights are rights that are guaranteed to human beings and recognized in international law.
Right.
So most people have heard of the Universal Declaration of Human Rights. Some may have heard of the International Covenant on Civil and Political Rights. These are two examples of what we call treaties that recognize human rights at the international level. And the United Nations is currently vested with the mandate to respect and promote human rights at a universal level. Fundamental rights are rights that are guaranteed under a constitution. So each country would have its own constitution and each constitution would spell out the fundamental rights that are guaranteed by those constitutions within that country. So that's the difference between the two.
Right. So what are our fundamental rights?
So Chapter 3 of our Constitution lists out several fundamental rights. They include the right to equality and non-discrimination, the right to be free from torture, the right to freedom of thought, conscience and religion, freedom of expression, so forth. There is a distinction between rights that are afforded to persons and rights that are afforded to citizens.
Right.
Additionally, what we need to know is that most of these rights, except the right to freedom of thought, conscience and right to be free from torture, can be restricted on grounds of national security, public order, public morality and welfare.
Right. So before I go to the protection side, are these the same in constitutions worldwide or similar vein, or are they different?
They vary significantly and there are many factors that contribute to or explain the difference. So in Sri Lanka alone, if you take the 72 constitution, the rights that we recognized in our constitution are slightly different to the rights that are recognized under the 1978 constitution. And if you look at the 2000 draft constitution, the fundamental rights that are recognized are much broader. Now, if we compare Sri Lanka with, say, the Constitution of the United States or the Constitution of India or the Constitution of South Africa, the fundamental rights guarantees vary significantly due to the thinking at the time as to what rights are as important enough to be recognized in a constitution and also in terms of the recognition of new rights. So, when we talk about human rights in general, scholars and lawyers and activists talk about certain groups of rights.
Right.
So one of the categories is civil and political rights, right to be free from torture, right to be free from arbitrary arrest, come within civil and political rights. Then we talk of economic, social and cultural rights. Now these are considered to be slightly different for reasons that I won't go into now. But right to education, right to healthcare are considered to be economic, social, cultural rights. Then we have another set of rights such as right to a healthy environment, right to development, which are considered to be a third category. So most of the constitutions that were adopted before 1990 only recognize civil and political rights as fundamental rights. Some of the new constitutions also recognize economic, social and cultural rights and also some of these what they call third generational rights.
Right. Which constitutions are those?
Very often in Sri Lanka, we talk about the South African constitution as an
Right.
example, but the more recent constitutions would be the Nepali constitution. And then also, if you look at India, they didn't recognize the right to education, but after their Supreme Court interpreted one of their existing rights,
Yes.
that is the right to life,
Yes.
to include the right to education, they amended their constitution to include the right to education.
All right. Okay, now our constitution, how does it protect these rights and what are the ways and means of protecting them?
Okay. So if we look at our constitution, it declares quite clearly that the state has the responsibility to protect all our fundamental rights. And by the state, we mean the executive, legislature and the judiciary. And that is the case all over the world. Human rights have to be protected by states. Now, if you take chapter 3, it spells out these rights and then declares that if any of these rights are violated by executive or administrative action, that is by the state basically, then you can go to the Supreme Court. You can go to the Supreme Court for a imminent infringement or actual infringement within 30 days by yourself or through an attorney at law. And file a petition. So that is the main remedy that is available for a violation of fundamental rights. In addition to that, you can file a complaint at the Human Rights Commission.
Right. Now, what are the remedies? You say how it is protected, how we can go. What are the remedies that will come if individually, if you go before a court, file a petition, and what would be the remedies? I know it's a broad area, broad question.
But that is also quite an interesting area because the Constitution says the Supreme Court has just and equitable jurisdiction, which basically means a very wide jurisdiction. So far in Sri Lanka, it has essentially meant one thing, and that is compensation.
Right.
At different, on a case-by-case basis rather, the court awards money, and it does so in 3 different ways. One is the court orders the state to pay compensation. Second, the court in certain cases orders the public officer concerned who has been held to have violated those rights to pay personally. And thirdly, the court orders costs, and that is generally paid by the state. Apart from compensation, we've had cases where the courts have said, now for instance in relation to school admissions, court will order that the child should be admitted to the school if they find that the child has been wrongfully denied admission. In certain other cases, the courts have directed the Attorney General to file criminal action against police officers who have been held responsible for violating the right to be free from torture.
Right.
Then we have a third category of cases, we can talk about it later, which we call public interest litigation.
I was to actually ask you later.
Where the courts have gone into different kinds of remedies.
Right. Now, you said about, basically punishing the person who violated it to restore the position that person lost.
Yes.
Am I correct? And then you also said about compensation. Now, these compensations, now unlike in a commercial law case, where you have legal interest you make on the loss or a violation of a contract, can person say, I want this much of compensation? Or if not, is the compensation given by court, is it reasonable?
Okay, so that's a good question. Very early on, in the famous case of Saman versus Leela Dasa, 2 of our most illustrious Supreme Court judges grappled with this question. So the majority in that judgment held that compensation under fundamental rights cases are only symbolic. And they said that for a very practical reason. They said ultimately it is the state that will pay this money, which means that it's the taxpayers' money that will be going out as compensation. Then in the minority opinion, it was argued by Justice Mark Fernando that actually the compensation should compensate the loss suffered.
Loss, exactly.
But then you still have to get around the question as to who will actually bear the cost of the compensation.
But you just said that sometimes the court orders the person who was actually responsible to making the decision, which was a violation of that person's rights, to give the compensation. So in that event, what happens?
There is some kind of message that goes out. And also, fundamental rights cases don't focus on punishing a wrongdoer. it focuses on the victim
Yeah.
and tries to offer some kind of a remedy. It may not be satisfactory. Now, if we study the compensation awards given by the courts over the last so many years, we see a huge variation.
Yes.
But I must say, I've just been reading the fundamental rights judgments of the Supreme Court in 2016. We can see a significant increase in the amount that has been awarded as compensation, both via the state and by the respondents. But it's a very difficult question. How do you calculate the loss suffered by someone who has suffered a violation of their right to be free from torture or arbitrary arrest?
So what I'm saying is, now coming back to that question, even if it is a person was made liable to pay personally, still it is like a nominal fee, nominal amount.
Well,
It
nominal is
not-
a relative
yeah, but it
term.
doesn't really compensate, like Justice Mark Fernando said, compensate the real loss that person feels in the heart, I lost. That is not
Probably
given.
not.
Probably not, whether the state paid or individually person pays.
Yes. There have been exceptional cases, and this case is well known, the case of Gerald Pereira, where the court ordered 800,000 rupees, I think 600,000 rupees to be paid as compensation. So that is one of the highest known figures that the court ordered to be paid as compensation. Except for those exceptional cases, in general, the compensation is symbolic.
Right. Is it the case, to your knowledge, worldwide?
No, not as far as I know. So it varies from country to country.
So you mean to say there are countries who give a massive amount of compensation, like in a damages case?
So that's the other point that we have to consider. We do have in our civil law remedies for seeking damages for loss suffered.
Right.
Whether those remedies are viable or not is a separate question, but that is another argument to support the idea that in fundamental rights cases the award should be symbolic, as a solace, and that's the terminology that the court used in Saman versus Leeladas, as to comfort the victim for the violation that he or she has experienced.
So you mean to say, if you get an award from compensation which you don't think that it is enough, can you go to the district court and file another damages cases based on that?
You might be able to. I don't know of anyone who has done that, but we've also had instances in which petitioners have, or rather the Attorney General's Department has filed indictment under the Torture Act.
Yes.
But of course you don't get damages there.
Yeah. Okay, now you mentioned that this is available for citizens as well as institutions. Correct?
Yes.
Yeah. Now, who can actually go before Supreme Court to file a fundamental rights case?
Any person, any citizen should be able to go. And any institution of which the majority are citizens of Sri Lanka should be able to go. We've had a very interesting case last year where the Supreme Court said a trade union most likely will not have standing before court. And then we've also had certain cases, namely the public interest litigation cases, in which individuals filing a case in public interest have also been allowed to go. We've had cases where individuals have gone on behalf of their family members and they have also been allowed to file action before court.
Right. So, a non-citizen, if he feels that his rights were violated by the executive or the administration, we'll say who has a working permit or something like that, or who was a former citizen, now a citizen in another country and didn't get dual citizen.
Yes.
Such people cannot
they can, for the rights that are guaranteed for everyone.
Yeah. What would be those rights?
Right to be free from torture, right to be free from arbitrary arrest, right to equality are some of those rights.
What are the rights they are not?
So that's Article 14.
14 rights.
Yeah. So freedom of peaceful assembly, freedom of association, freedom to form and join a trade union, freedom of expression, etc.
Right. Now, you were mentioning about the public interest litigation regime. Is it applicable or is it available in Sri Lanka, or is it properly not practiced, or is it?
Right.
How does it work?
So public interest litigation took off in a very significant way in India, 1980s onwards. And we have often looked to India in finding inspiration for adopting litigation strategies for public interest litigation in Sri Lanka. Now, if you look at Article 126, which describes the remedy for violation of fundamental rights, the text is very clear. It says a person by himself or by an attorney at law can go to court, which means no one else can go to court. What has happened over the years is that court in certain cases has given a liberal interpretation to Article 126, and like I said, has allowed organizations acting in the public interest, individuals acting in the public interest to file petitions. So we've had periods in which we've had intense litigation in this area, periods in which we haven't had such litigation, and I think currently we haven't had any significant public interest litigation cases. So if you look at the text of the Constitution, it doesn't allow for public interest litigation, but in practice, at certain times, our courts have recognized public interest litigation.
Okay. How would you define public interest litigation?
That is also very interesting because you can give a broad interpretation and say that even if a victim goes to court and files a fundamental rights action, there is a public interest component in that, because he or she is not only defending his fundamental rights, but it has a symbolic value or a normative value for rest of society. But over and above that, if someone who, okay, let me backtrack. In law, we generally say in order to be able to go to court, you have to show that you have been affected in a unique manner, over and above everyone else who has been affected. But there could be violations of fundamental rights which affect the public at large, and because it affects the public at large, one person may not be able to go to court and establish that he has been affected in a unique manner. So that is when you need organizations or individuals acting in public interest going to court. A very well-known case is the case of EFL versus UDA, what is known as the Goldface Green case. There was a purported lease of Goldface to a private company, and it seemed like the public at large were going to be affected by that decision of the government at the time. So Environmental Foundation Limited, an organization working towards environmental justice, took the case to court. So that's an example of how individuals or institutions acting in the public interest, acting in good faith, can take a case to court.
Right. Okay. Now, this Human Rights Commission, there's a link we see between the Human Rights Commission and the Supreme Court with regard to fundamental rights and human rights. Can you explain this?
Okay.
Because people tend to get confused between these two. Yeah.
Right. So the Supreme Court exercises judicial power. The Human Rights Commission does not exercise judicial power. At the most, the Human Rights Commission can make recommendations to state authorities to take measures. They cannot compel them to take action. So that's the most significant difference between the two. I said earlier that if there's an imminent infringement or an infringement, within 30 days you have to go to court. Now, there have been instances in which individuals have gone to the Human Rights Commission first because they are more familiar with the institution and it's accessible, particularly geographically more accessible than the Supreme Court. And it's now the established law is that if you have gone to the Human Rights Commission within those 30 days, time will not run against you until the Human Rights Commission makes a determination on your case. So even if the Human Rights Commission does make a determination on your case, either in your favor or not in your favor, you can still go to the Supreme Court. It doesn't prevent you from going to the Supreme Court.
Right. Yeah, we are having a lot of questions, but time is limited. But I have these two major questions I had to ask. What are the significant judgments, developments have you seen in the recent past? And I will couple my other question with that so that you can probably answer them together. The current constitutional reform process, are there any changes that are subjected for the fundamental rights regime?
Okay. So I have with me numbers in terms of judgments that have been filed in the Supreme Court from 2010 onwards. And what we can see is that most of the cases are filed under Article 12, that is the right to equality. And interestingly, most of these cases relate to either public servants, challenging recruitment, promotion or transfers, and school admissions. And then we have a certain number of cases which allege torture. Now, in the last year, we've had several interesting cases. One was a first in Sri Lanka where sexual harassment was interpreted to be part of a violation of the prohibition on discrimination and therefore part of your right to equality. You have the right not to be subject to sexual harassment in the workplace. And it was a very progressive judgment. The court cited the relevant international convention, CEDAW in this case. So that is a significant development in Sri Lanka. Then if you also look at the case in which torture was alleged, the Supreme Court has been quite progressive and described torture or cruel or inhuman and degrading treatment or punishment in very broad and practical ways. So there also we have seen progress. And there are several other cases as well. So we see a very progressive trend in the Supreme Court. If you talk about the proposed reforms to the Fundamental Rights Chapter, there are many. Something that, so in terms of the categories of rights, civil and political rights, economic, social, cultural rights, environmental rights, group rights. And for the first time, we have included, or rather the Constitutional Assembly, the subcommittee has included rights of persons with disability, rights of elders, and then we've continued.
Group rights will include trade union rights.
Trade union rights are already included in the 78th Constitution. So the previous draft is the draft under the 2000 draft Constitution. So we've carried forward some of those progressive interpretations and added to those. And they've also proposed that the Court of Appeal be given the jurisdiction to determine fundamental rights applications. And the idea there is to make the fundamental rights jurisdiction more accessible. And finally, petitions made in the public interest have been expressly recognized as permissible under the fundamental rights jurisdiction.
Okay, this is a question I always have. Why 30-day limit to file? Because if you look back, even in the labor law, we had a situation where now labor law, you can go to labor tribunal within 6 months. Earlier, there was a lesser time of period. So why 30 days? Has this been looked into in the proposed reform? And the second thing is, when you file, you see there's a progressive suggestion about filing it in Court of Appeal. Will there be an appeal from there to Supreme Court if you are not satisfied with the fundamental rights judgment you get?
So to answer your last question, there is no provision for appeal at the moment. Of course, these are draft proposals.
So instead of Supreme Court, they are suggesting Court of Appeal.
Court of Appeal. And it has been said, not in this report, but it has been said that the Court of Appeal may sit in the provinces as well. In terms of the 30-day limit, the idea is that individuals who sleep on their rights should not take the time of the court.
Yeah, but in every other case, we have more time than that. Written contract is 6 years, damages 2 years, LT 6 months. So as you can see, practitioners see, it's impossible sometimes to get the documents across. And then you go to amend the petitions and all that. There's all sorts of problems. So don't you think, my suggestion, don't you think it's practical? Two things. To have it a more time period, at least 2 months to 3 months, and have an appellate process beyond the Supreme Court, beyond wherever the court it is given.
So two responses. One is the Supreme Court has also had a flexible approach to the 30-day limit. They have in many cases had a case-by-case approach and looked at the ability of the petitioner to come to court. And
Hello, good evening and welcome to another episode of Law and Order on another Friday evening. The program that features a specialized area of law with a specialist in order to bring you knowledge and awareness of it. Now, we all heard the term fundamental rights or human rights. We tend to usually confuse these two. But today, in order to find out what is the fundamental rights situation in Sri Lanka and what rights you have on fundamental rights, and to little bit go beyond that and see how it is working here, we have a special guest on that. And my guest today is Dr. Dinesha Samaratna, Senior Lecturer of the University of Colombo, specialist in fundamental rights among her other areas. Dr. Dinesha, thank you very much for joining us again.
Thank you for having me.
And let's straight away start on with the question. Like I said before I go to the questions, people tend to confuse fundamental rights and human rights as well. So what is the fundamental rights and how are they protected in the Constitution in Sri Lanka?
Okay. These are two different terms.
Right.
Human rights are rights that are guaranteed to human beings and recognized in international law.
Right.
So most people have heard of the Universal Declaration of Human Rights. Some may have heard of the International Covenant on Civil and Political Rights. These are two examples of what we call treaties that recognize human rights at the international level. And the United Nations is currently vested with the mandate to respect and promote human rights at a universal level. Fundamental rights are rights that are guaranteed under a constitution. So each country would have its own constitution, and each constitution would spell out the fundamental rights that are guaranteed by those constitutions within that country. So that's the